Be ready. Start. Dated this the 23rd day of December 2015, Common Order accused 2 and 3 in crime number 1036 of 2015 of Adimali Police Station seek pre-arrest bail under section 438 of the Code of Criminal Procedure, para. Heard the learned senior counsel for the second accused and the learned counsel for the third accused. Learned Additional Director General of Prosecution also advanced the arguments. Perused the case diary, para. Prosecution case in nutshell is as follows. Sakir is the de facto complainant. His brothers Muhammad Imran and Muhammad Yusuf, along with himself, owned 27 cent of land at Adimali. Due to financial constraint, they mortgaged 8.5 cent of property for rupees 20 lakhs in favor of selling about 1 years before the incident. As they could not pay back money within the stipulated time, they entered into an agreement with the first accused in the crime. Accordingly, he advanced an amount of rupees 20 lakhs to the de facto complainant and others for clearing the liability towards Salim. An assignment deed was executed by the de facto complainant in favor of the first accused for securing the amount advanced by him. The understanding between the de facto complainant and the first accused was that when he paid back money, the first accused should retransfer the property in the name of the de facto complainant. 18 cents of property belonged to the de facto complainant and others was also assigned to the first accused on condition that a commercial building will be constructed on the land by executing a joint agreement. It is interesting to note that all these collateral agreements were only payroll ones and no documents was created. It is the case of the de facto complainant that although the first accused initially agreed to build on the land, later he rescinded from the agreement and asserted ownership over the land. It appears that the case of the de facto complainant is that he did not assign the land with absolute title and possession to the first accused. There was only a loan transaction for which the documents were executed to secure the amount. It is evident from the materials that there were disputes between the first accused and the de facto complainant in respect of the land deal. Second accused is the power of the attorney holder of the first accused. While so, on 17/10/2015 at about 2 o'clock in the night, the accused person, about 13 in number, came to the property of the de facto complainant armed with deadly weapons. They pulled down the structures by using an earth moving machine and damaged vehicles kept in the workshop set up in the premises. They scared away the inhabitants of a building and employees in the workshop. They also attacked the de facto complainant in crime number 1035 of 2015 of the same police station. It is further alleged that for demolishing the structures, the accused person, in addition to the JCB, used explosive substances and thereby committed the offences punishable under section 143, 147, 148, 120b, read with section 149 of the Indian Penal Code and section 3A of Explosive Substances Act 1908, para. Learned senior counsel appearing for the second accused contended that the prosecution case is totally unbelievable and improbable. Second accused produced documents in bracket annexure A1 to A17 to advance his contention. Learned senior counsel contended that the prosecution developed a story which is at variance from the version of the de facto complainant in annexure A3 first information statement. It is seen from annexure 3 that the statement of the de facto complainant was recorded at 11:13 a.m. On 17/10/2015, Annexure A2 is the first information statement in crime number 103 of 2015 of the same police station. The first information statement was recorded from a hospital wherein the injured de facto complainant was admitted. It is contended on behalf of the second accused that none of these first information statements revealed the factum of financial transaction between the first accused and the de facto complainant. Learned senior counsel also relied on copy of registered documents executed by the de facto complainant and others in favor of the first accused to contend that the disputed property and the structures thereon now exclusively belong to the first accused. Extortion, being an aggravated form of theft, cannot be committed by the owner of the property. Therefore, the foundation of the prosecution case is weak. Stop.